Yes, just minutes ago, actually, folks, a federal judge approving the move that had been expected ever since former President Donald Trump became President-elect Donald Trump. And so today, what was expected indeed becoming reality, bringing to an end a dramatic chapter in American history.
Special counsel Jack Smith today filing motions to drop all charges against President-elect Donald Trump. It involves his alleged effort to overturn his 2020 election defeat and promoting false claims of a stolen election in the lead-up to the January 6th attack. Trump was charged with conspiracy to defraud the United States and obstruction.
The attack on our nation's capital on January 6th, 2021 was an unprecedented assault on the seat of American democracy. As described in the indictment, it was fueled by lies.
In his filing, Smith said the merits of the prosecution's case have not changed, but the circumstances have. Smith saying, as a result of the election and DOJ guidelines against prosecuting a sitting president, the case will not go forward.
Hi, buddies. Adam is here. There is a nightmare scenario unfolding for Donald Trump right now, and it is happening in complete silence. While the media chases the daily chaos of White House press briefings and the latest Truth Social meltdown, a parallel universe is operating behind thick courtroom doors that Trump cannot control, cannot delay, and cannot spin his way out of.
The judge overseeing former President Donald Trump's classified documents case held a sealed hearing today on Trump's efforts to have the entire case dismissed. Overnight, prosecutors filed these never-before-seen pictures of classified documents found during the FBI's 2022 Mar-a-Lago search. It was in response to the former president's claims that investigators mishandled the materials found in boxes. CBS News campaign reporter Katrina Kaufman is outside the courthouse in Fort Pierce, Florida. So, Katrina, catch us up to speed on these late overnight filings.
Hi, Lindsay. So last night, Jack Smith submitted a filing in which he responded to a claim by Trump that this is yet another effort to dismiss this indictment, first of all, and it's because Trump says that his due process rights have been violated by the government because they've tampered with the contents of these boxes that were found during the Mar-a-Lago search and in which the classified documents were found.
This is a universe made of sealed filings, locked evidence lockers, and grand jury transcripts that have never seen the light of day. And inside that universe, something terrifying is taking shape for the former and future president. We are not talking about speculation. We are not talking about rumors leaked by anonymous sources with an axe to grind. We are talking about real legal documents, real sworn testimony, real physical evidence that exists right now in the federal court system.
He also says that the special counsel's office had a meeting where the order of the contents were discussed and he didn't receive the notes. So he says all of this is a reason that they should just dismiss this case completely because this evidence has been spoiled. Now, Jack Smith's filing was very sharply worded. First of all, he says that Trump is offering no cases that support this claim, that this has never been done before, and also that the 11th Circuit, which is what Judge Cannon's court is in, has never found that the government violated a defendant's due process rights by losing or even destroying evidence.
Evidence that judges are reading in private, away from cameras, away from political operatives, away from the noise. Evidence that paints a picture of Trump's conduct so detailed, so damning, and so comprehensive that it could ultimately determine not just his political future, but whether he ever breathes free air again. The question everyone should be asking is not whether this evidence exists. It does. The question is, what happens when the seals break and the world finally sees what is inside? Now, I need to be precise with you because there are videos out there screaming that prison is a done deal, that judges have already signed off on life sentences, that the whole thing is over. That is not where we are. Overstating the case actually weakens the argument. What we have is something far more dangerous for Trump than a single verdict. We have an avalanche of accumulated evidence, compiled across multiple jurisdictions, involving multiple judges, built from the inside out by people who were in the room. And that avalanche is sitting frozen, waiting for the moment the legal process thaws and lets it roll. Let's start with what is actually sitting inside Judge Tanya Chutkan's courtroom in Washington, D.C. This is the federal election interference case, and it is ground zero for the sealed evidence phenomenon. Special counsel Jack Smith has filed a sealed evidentiary package with Chutkan that is absolutely massive. We are talking about grand jury testimony, FBI interview memos, documentary exhibits, and forensic evidence drawn from witnesses whose names you already know: Mike Pence, Ivanka Trump, Mark Meadows. These are people who occupied the innermost circles of power during the post-election period. People who watched Trump make decisions in real time. People who heard what he said when the cameras were off. Prosecutors told the court that this sealed submission contains what they called sensitive and previously unseen evidence. Evidence specifically designed to prove that their case survives the Supreme Court's presidential immunity ruling. That is the legal jargon. In plain English, it means Smith has material so powerful that even the most conservative interpretation of presidential power cannot shield Trump from it. And then in October of 2024, Judge Chutkan did something that gave the public its first real glimpse behind the curtain. She unsealed nearly 1,900 pages of previously hidden documents. 1,900 pages of evidence that had been locked away, now suddenly public. And what emerged, even in heavily redacted form, was devastating. Detailed accounts of Trump's knowledge, documented proof of his intent, sworn testimony from his closest advisors describing exactly what he was told and exactly what he chose to do with that information. But here is the part that should send chills down anyone's spine. Those 1,900 pages were just the material Chutkan decided was safe to release. The evidence still under seal, the material still locked in courthouse vaults, is the stuff deemed too sensitive, too classified, too explosive for public consumption right now. If the redacted version was that damaging, what does the full version contain? Think about what it means for Trump's legal team to operate in this environment. They know the evidence exists. They know Pence testified. They know Meadows flipped. They know Ivanka spoke. But they cannot see everything. They cannot fully prepare responses to testimony they have not reviewed. They cannot fully counter evidence they have not seen. That information asymmetry, the prosecution holding all the cards while the defense plays blind, is a tactical nightmare for any lawyer. Now let's move to Florida, because the sealed evidence picture is not confined to one courtroom. In the Mar-a-Lago classified documents case, the situation is even more extreme. This is the case built around Trump's retention of some of the nation's most sensitive secrets after leaving office: 40 felony counts, classified exhibits that only attorneys with top-secret clearance can view, and a sitting president operating under a court-imposed protective order that restricts his own access to evidence in his own criminal case. Think about how unprecedented that is. The President of the United States cannot review key evidence against him without his lawyers standing over his shoulder in a secure facility. That is not normal. That is not how democracy is supposed to work. And the sealed filings in that case, the classified attachments, the secure exhibits, contain the factual foundation for those 40 felony counts. They describe in detail what Trump took, what he showed to people without clearance, and what he did to avoid giving it back. That evidence exists. It has been authenticated. It is sitting in a courthouse in Florida waiting for the legal process to determine its fate. And then there is Jack Smith's final report. This is another piece of the puzzle that deserves far more attention than it gets. Smith completed his investigation and submitted a comprehensive final report detailing his findings in both the election case and the documents case. Trump fought like hell to block its release. He lost. The report came out, and it describes in extensive, documented detail criminal conduct by Trump across multiple areas of investigation. Legal analysts who understand how these reports function in the federal system make a specific point that most people miss. That report can be used at sentencing. When a federal judge is deciding what sentence to impose on a convicted defendant, they are required by law to consider the full scope of the defendant's conduct, not just the specific counts of conviction, but everything relevant to understanding the nature and severity of what they did. Smith's report, comprehensive, documented, damning, is exactly the kind of material a sentencing judge can draw on to justify serious time. Let me tell you about something that operates completely below the radar of political coverage but matters enormously for Trump's long-term exposure. It is the way judicial findings in one case become ammunition in others. When Judge Chutkan reviews sealed evidence and makes a ruling, even a procedural ruling about immunity or admissibility, that ruling contains implicit findings about Trump's conduct. It reflects her assessment of what the evidence shows and how Trump's defenses hold up against specific facts. Prosecutors in other cases can cite those findings. Other judges can reference them. And over time, these findings compound. They build on each other. They create a legal landscape where every new ruling makes the next one easier to obtain. This is the slow, grinding, unglamorous process by which the law actually closes in on powerful people. Not through one dramatic moment, but through the accumulation of findings, rulings, and records that make escape progressively harder. Now consider the witnesses whose testimony is sitting in that sealed package. Mike Pence, the former vice president, the man who was in the Capitol when the attack happened, the man Trump pressured publicly and privately to reject the electoral count. His grand jury testimony, sitting in Chutkan's chambers right now, describes what he witnessed from the second highest office in the land. Ivanka Trump, the president's own daughter, present in the White House during the critical weeks. Her account of what happened inside the building is part of the record. Mark Meadows, the former chief of staff, his cooperation and testimony about Trump's knowledge of the fraud claims being baseless is arguably the most damaging piece of insider evidence in the entire case. All of that testimony exists. All of it is sworn. All of it is sitting there waiting. And here is the broader context that ties it all together. The Supreme Court's immunity ruling created a framework, but it did not resolve every question. The sealed evidence Smith submitted to Chutkan is specifically designed to address that framework, to show that even under the most protective reading of presidential immunity, Trump's conduct falls outside the protected zone. As the immunity litigation gets resolved, as courts work through specific questions, more of the sealed record becomes relevant and potentially releasable. The resolution of immunity questions is the key that unlocks different pieces of the evidence package. Let me give you 4 reasons why this sealed evidence picture is genuinely significant, even in a political environment where these cases have been slowed and complicated by Trump's return to the White House. First, sealing is not permanent. It is a temporary condition reflecting a court's judgment about what is appropriate to make public at a specific moment. Sealed documents get unsealed when trials start and exhibits need to be entered. They get unsealed when sentencing requires the full record. They get unsealed when appellate courts demand transparency. Every piece of evidence currently sitting in Chutkan's possession, every transcript, every note, every exhibit from Pence and Meadows and Ivanka is going to become public at some point. The question is not whether it comes out. The question is when. Second, cross-case corroboration is devastating to Trump's defenses. One of his primary arguments is that each case is politically motivated, that each prosecutor or judge has a bias. But when multiple judges in multiple jurisdictions, appointed by presidents from both parties, all arrive at similar findings based on independent records, that political motivation argument collapses. When Chutkan's findings echo Smith's final report, which echoes the New York fraud findings, which are reinforced by Meadows' testimony, that convergence is very difficult to explain as coordinated persecution. Third, sentencing is where the full weight of this record lands. If Trump is ever convicted in any of these proceedings, the sentencing phase is where everything comes together. At sentencing, a federal judge can consider the full scope of relevant conduct, not just the specific charges. Smith's final report, the sealed evidence packages, the grand jury transcripts, the judicial findings about what Trump knew and intended, all of that forms part of the sentencing picture. A federal judge looking at the full scope of what the record shows has both the evidence and the precedent to make very serious decisions. Fourth, this is the most comprehensive documented record of alleged presidential criminal conduct in American history. It was assembled through years of investigative work, grand jury proceedings, compelled testimony, and careful legal strategy by experienced federal prosecutors. It exists in a form that is much harder to dismiss than leaked documents or anonymous sources, sworn testimony, authenticated exhibits, court findings, and the political circumstances that have currently slowed active prosecution do not erase that record. They pause the timeline. They do not make the evidence disappear. They do not change what witnesses said under oath. They do not alter what the documents show. So where does that leave us? It leaves us with a situation where the most significant legal evidence ever compiled about a sitting American president is sitting in sealed court filings, being reviewed by federal judges, cited in non-public legal arguments, and waiting for the legal process to determine when and how it becomes fully public. It leaves us with a record that includes sworn testimony from the former vice president, the former chief of staff, and the president's own daughter, all describing events from inside the White House in ways that directly implicate Trump's knowledge and intent. It leaves us with 40 felony counts supported by classified exhibits that only cleared attorneys can currently review. It leaves us with a final prosecutorial report describing extensive criminal conduct that legal analysts say is specifically designed to be used at sentencing. Prison is not inevitable tonight. No judge has issued a sealed verdict. The timeline is uncertain and the political environment is hostile. All of that is true. But the idea that the sealed record does not matter, that the accumulated evidence is neutralized by current political circumstances, is not supported by how the federal legal system actually works. Evidence does not expire. Grand jury testimony does not disappear. Court findings do not get erased because the political winds shifted. Every judge reading those sealed packages right now, every judge going through grand jury transcripts and FBI interview notes and documentary exhibits from the people closest to Trump during the most critical moments is building a judicial understanding that will shape every future proceeding. The record is being written. Most of it is still sealed. And the day it starts coming out in full, the day those courtroom doors open and those exhibits start going up on screens in front of juries, will be one of the most consequential days in American legal and political history. The next unsealing order from Judge Chutkan could be the moment the whole hidden record starts coming into the light. And when it does, nobody is going to be able to look away.